No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that particular legal question that doesn't quite fit into the other topics we discuss here on the Law Report. And just before we begin, a reminder that there's a list of available documents on the Facebook page, Law on SAFM. If you'd like any of them, please post a message there. And remember to include your email address so I can send them to you. And if you don't have access to Facebook, you can email me on law@safm.co.za. I'll send you a copy of the list and then you can choose what you'd like to have. Well, I'm joined once again this evening by attorney Nicolene Skuman-Low, director of Skuman Law Inc., attorneys, conveyancers and notaries public. Nicolene, good evening. Welcome back to the show.
Hi. As always, thanks for having me.
Well, if you have any questions, you can call us on 0892 10 2010, 0892 10 2010. We just have a few emails to get through, so if you call through now, you can just leave your name and number with my producer and we'll call you back as soon as we're done. Right, the first one is an anonymous query from a listener. It says, my question relates to the devolution of an estate of a person whose great-grandchildren currently reside with her. Although the scenario is linked to a real situation, some of the aspects are hypothetical. In the scenario, the Mrs. X, who's widowed, has 2 living children who are beneficiaries to her estate. The essence of my question has to do with her fixed property, where she resides with the grandchildren of her predeceased son. She had 3 children in total. This is Mrs. X's 2 surviving children are the legatees of the fixed property in her estate. Question 1. If she passes away first, will the minor great-grandchildren have a claim on the estate, and in particular the fixed property, as they could be considered to be financially dependent on her? And then there's some additional information. It says the divorced parents of the minor children are either completely or partially unemployed, but mostly irresponsible. And the testator is a pensioner, a normal state pension, but her income is occasionally supplemented by her surviving children. And the second question is, how did the testator and beneficiaries protect their wishes in terms of the will and interests in this situation? The great-grandmother is merely caring for the minor children as their negligent mother intermittently resides with them and at times disappears.
Well, this is a very complicated situation, and normally if the children were predeceased, in other words, children to the grandparent in this case, then that child of that deceased person could represent them in intestate succession. So any children of a predeceased child of someone else can step into their shoes and inherit in terms of intestate succession.
She says here, though, which was a bit confusing, she resides with the grandchildren of her predeceased son. But then she a little bit later on talks about caring for minor children as their negligent mother intermittently so the mother's still alive.
It would seem like one of the parents
it would be her daughter-in-law or great whatever it was.
We have to assume that this is not the blood child, but the child related by marriage, the in-law, in other words. So we have to assume that, and if that is the case, then the 2 children will represent the deceased child. So in terms of intestate succession, what strengthens the claim is the fact that, you know, these are very complicated situations that families would find themselves in. The problem is that this is a child that has become financially dependent, but there's been no adoption in most cases, no formal adoption. So when the grandparent, in this case, great-grandparent, passes on, you often have a situation where these kids do make application against the estate for maintenance because they have become financially dependent. Often this is argued against, the counter-argument, in other words, being that they were never formally adopted. So it's really something that the courts do consider from both sides. But depending how young they are and how much of a contribution the mother or the father, in this case, have made, that's something for the court to decide whether or not they will award a claim against the estate, even until they only reach the age of 18. I mean, you have to look at the interests of the child also. The child will not be left destitute because of a formality that hasn't been fulfilled, a formal adoption, in other words, that hasn't been forthcoming. So there's a very good chance that if such a claim was to be made, that it could be successful. But every case needs to be judged on its own merits and the degree of commitment and support that has been given versus that which has not been given by the biological parent. How to resolve this? Well,
because he specifically focuses on the fixed property, and there are 2 surviving children, and then there are the grandchildren or the great-grandchildren.
Yes. So we have to assume that the child, I know this is very difficult to explain on air when we can't have a visual element to it, but if there's one separation in a generation, we have to assume that that person is also predeceased. So if it can go down one more line, and this mother that is referred to in the email is in fact the daughter by law, in other words, the daughter that was married to the biological blood-related son, then we have to assume that these kids can represent their deceased father, and that his father is also deceased, or mother, as the bloodline would work in that case. The only way to fix this, or to regulate it past what potential claims and potential litigation could flow out of this, would be to have a will executed, and that the grandmother, great-grandmother rather, decides how she would want this to work. Perhaps sit down with the family, decide what would be fair, considering maybe that the mother is not going to be looking after these kids.
Because also the email says there are 2 living children who are beneficiaries to the estate. And then he also says the 2 surviving children are the legatees of the fixed property in her estate.
Well, I mean, legatee in legal terms is a very different thing to what the listener has recorded here. So I've just read that to be an heir. A legatee is someone that gets some cash or gets a specific item. So it really depends. I think let's keep it simple. And if you don't want a potential piece of litigation to occur, then it's always good to have a will structured, sit down, decide what you think is fair, put that in writing, and have it be dealt with like that. In terms of a fixed property, remember, a fixed property cannot devolve upon children, minor children, unless they are over the age of 18. Any potential portion that they could inherit, they would obviously it would be held in sort of trust, if I can use that word loosely, in the Guardian's Fund. So all in all, it's really good, and I think maybe it's fortuitous that it's Wills Week, and we can remind listeners that there is an opportunity now for you to have a will done. But
this wouldn't fall into that because there's property involved, and Wills Week doesn't include people with property and stuff.
Not necessarily. I mean, you could inherit a property but be unemployed. That doesn't, I think, determine financial standing. Similarly, you could be the beneficiary of a RDP house or a low-income or low-cost housing. So I don't think that really determines whether or not you've got the financial standing to afford a will, to pay for one. I think it's really about whether you're employed or not. If you're not, if you're a pensioner and you're on a very, very minimal state pension, those are things that I think would preclude you from being able to get yourself a professionally drafted will, as opposed to maybe taking the money and applying it to the basics, the food and the clothing and all of that for your family. So I think we need to look less at if there's a fixed property registered in someone's name, and more at, are you employed, yes or no? Are you maybe disabled?
Are you on pension?
Pension, something like that.
Okay, and just a reminder that, as we said, it is National Wills Week from today until Friday of this week.
Yes.
And if you are wanting to know if there are attorneys available who are participating in the National Wills Week in your area, you can just drop me a mail to law@safm.co.za, and I'll send you the participating attorneys in your area. But please do tell me where you are, because I have a number of I must say, I'm actually been so impressed with the number of emails I've had over the last few weeks from people who want to go and do this, but they don't tell me where they are. Please send me the list. I'll send you the list, but there's a lot of attorneys in the whole country. I'm sure you don't want all of them. Just send me the area that you live in or you work in and where you'll be able to get to. I'll send you the list of those relevant names and contact details, so do that. Right, our next email is from Patrick, who says, my wife was married to me in community of property and she passed on. When she passed on, we had a bonded house which we were still owing money on. The question is, must the remaining spouse continue paying the monthly premiums for the house, or must the debt be written off? What is the law saying with regard to this?
Well, unfortunately, remember, if you have a marriage in community of property, then you create one estate between two people, one undivided estate, which means that whoever dies first does leave the other in a bit of a pickle, in terms thereof that you cannot just sell off assets and all of that before the estate process hasn't been finalized. You automatically retain your 50% of everything, including the house, including the debts, and the 50% of your deceased spouse is really the portion in question. Usually with bonds, the banks do require a insurance to be taken out, life insurance, so that the spouse being left behind doesn't face the situation of having to afford two bond payments, essentially. Many people, if for whatever reason the life insurance isn't sufficient or has never been taken out, it's unlikely, but if that is the situation, then you have one of two choices really as the surviving spouse. You can either pay both installments and pay the house up, or if you can't afford that, the alternative is unfortunately to sell the property and to scale down maybe to something a little smaller, where one bond payment could then be sufficient instead of taking on a second. So that's, again, it's quite key. I think whenever one has debt, regardless of the origin of it, it's very important, A, that you have a will, and B, that you have some insurance provision in place so that this doesn't become your reality. But unfortunately, it doesn't get written off. No,
I was about to say, unfortunately, that doesn't happen. So, Patrick, I'm so sorry, but you are still liable for that payment.
Unfortunately, jointly and severally, and that's one of the de facto positions with a marriage in community of property.
Right, another anonymous email says, almost half a year ago, on the 15th of March this year, I applied for Pro-Bono Assistance at the Cape Law Society, which application in regard to one aspect thereof was approved shortly thereafter, and I received written confirmation from the Pro Bono coordinator a month later. Grateful for this apparent lifeline, my hopes have turned into great anxiety as no attorney appears as yet to have been appointed, and I've received no further communication in my case. Not being in a position to undertake anything on my own and growing increasingly concerned that the delay in being able to proceed with my case is providing leeway for aggravating the situation, I tried calling and writing to the Cape Law Society, which in effect has been to no avail. And then being nearly 60 years old, single, unemployed female, that has become destitute, I'm writing to ask if you could possibly assist in getting my case moving or advise me what I can do under the circumstances. And this listener says doesn't want to lay a complaint with the Law Society, as I understand they are having to deal with an increase in pro bono applications. But what is the story with something like this?
Well, purely from a recipient of a pro bono instructions perspective, I've seen that once someone makes application, the Law Society does actually go through a list of potential practitioners that could be able to assist, and then writes to them asking whether or not they'll be willing to take such a case on. Unfortunately, that's often where the delay does happen, particularly because they are, in the current economic climate, obviously getting a lot more of these applications than a couple of months or years ago. So that's really between the application or the Law Society saying this is something we could do pro bono, they start calling on practitioners, and that's really where the delay often lies. Not always, but often. The listener can, of course, if by the sounds of it, she is able to apply for legal aid, which is something similar to pro bono. It's a separate institution from the Law Society per se, but they are very much geared at assisting, particularly in litigious situations. So until the outcome happens, that could maybe be an avenue to explore for the listener to approach the legal aid board and to see if you can't get someone appointed that way. And then also to just continue phoning and liaising with them.
But there's nothing we can do to actually make the case move forward faster.
Unfortunately not. No, it will have to be a call through the Law Society's channel themselves. One can always also apply to the Bar Council's Pro-Bono initiative. They run a very similar initiative, but that's under the premise that it's a high court matter or a higher court matter than magistrates court level, and that it's maybe fairly more complex. So again, it takes a little bit of time, but that's the alternative, unfortunately.
There are a few other options, but as you're saying, it's unfortunately a case of being patient.
Yes, unfortunately, particularly if it's going to be done on a pro bono basis. It's very hard, really, to escalate it any further. Your only channels are really the Law Society, the Bar Council, or the Legal Aid Board.
Right, so listener, sorry about that, but unfortunately that is the case. Right, Kamal says, is a will that is lodged with the Master's Office a public document? Now, he's read two magazines. One says it is. The other one is a letter from an attorney which was written to the Rebus, which is a magazine for attorneys, suggests otherwise. The Department of Justice, as I understand the letter, he says, is of the view that a will is private and confidential, and that any person who wants access to it needs to show what right he or she is protecting or exercising. And he would ask specifically your opinion on that.
We have never experienced any refusal from any of the public offices, including the courts and the Master's Office, to get copies, or the Deeds Office for that matter.
But you're an attorney.
I'm an attorney.
That would be maybe different to just a regular Joe. If I walked in, for example, and said I'd like a copy, would they be quite happy to hand it over?
I must be quite honest. I've dealt with many clients over the years that have... even I'm thinking of a matter I'm currently dealing with that the client attempted to deal with themselves, and when they weren't able to resolve the matter, they ended up in our office, and they had driven the matter for about 8 months themselves and obtained copies from different masters' offices, and didn't have the funds to deal with it in any other way. So that tells me when I hear stories like that on a fairly regular basis from clients, that it's not because of a law firm that we apply. Now, of course, the master can, if he feels it would be against public interest or something, refuse that you have access to a document, and then you could follow some of the procedures to say, I would like reasons why this information has been refused to me. There's a couple of pieces of legislation that deals with obtaining information, and it just needs to happen in a prescribed format. If it doesn't get delivered to you, then you are entitled to reasons and all of that. We've got various pieces of information. The Promotion of Access to Information Act, PAIA, as we loosely refer to it in our profession. That is one of the pieces of legislation that most public bodies have to have in place in order to help the public obtain documents that are maybe in the category of not quite a public document, but if there's no interest being affected adversely, it's not a state secret, then we can release the document. So I haven't been privy to the two documents that the listener does refer to. There unfortunately wasn't an attachment, and I did actually look on our database that whether or not I could find this particular letter to the Rebus, which I couldn't. But overall, I haven't experienced this refusal. And if there is a refusal, particularly when you want to obtain a copy of a will, then you are entitled to reasons for the refusal in terms of the legislation I've just mentioned, and to request it formally as the Act prescribes. So if that's been exhausted and the reasons are reasonable that have been given, and you don't have a stronger right or a right that outweighs the other, if I can put it less informally, that you feel needs protecting, then again it's a constitutional balancing act, and they can lawfully refuse then. So it really depends why one wants the document, what is maybe contained in the document that this public office feels would be compromised if they were simply to release it. But as I've said, with all of this being said, that's the theory. In practice, I've seen it over and over where application is made by the normal guy on the street to get a copy, and they do.
Okay. Right. Andy says, I bought a car which broke down after a few months. I paid the seller in full, and as was in the agreement of sale, it was signed. Due to prohibitive costs of repairs, I decided to sell the car as a non-runner before the change of ownership to my name. I explained to the buyer that it's not yet in my name, but for the sake of honesty, I showed him the registration book and agreement of sale. The buyer came with his mechanic and his wife, paid half of the agreed amount. Because of cash withdrawal limitations at their bank, they towed the car. He promised to bring the balance the following day and to collect the agreement of sale and the car registration. He never came back. I then discovered after 9 months that he'd paid the original owner R1,000 and got a duplicate registration. I still have the original registration book and the unsigned agreement of sale. I wish to repossess the car due to non-payment. Please advise. So basically half the price of the car, and they towed it off and never came back. And then went behind his back and got the rest of the stuff from the original owner. That's a little bit...
That's a very unfortunate situation, but unfortunately a lot of things are against this listener. And firstly, not taking ownership himself, from what I understand. Sort of on selling before the registration had been passed over to him. Not having a signed agreement in place, taking cash, so there's no proof where the money that he did receive, where it came from. It is possible to approach court for an order to allow you to repossess this vehicle, but there are so many challenges, and I just want the listener to be aware of all these challenges. Really, you're dealing with, there's no proof of an agreement in the first place. So
there's no proof of ownership to start with.
Proof of ownership, the most obviously. Then there's no proof of the actual sale. There's no proof of the half of the money that was indeed paid. So it could really become a classic case of he said, she said, which could escalate and become much more costly than simply calling it what is probably very bitter to admit, some school fees, and in future to rather wait, be patient, get the transfer done properly, get all the tests and the roadworthiness and all those other tests in place, make sure that you've got all of that in your agreement, get it signed, and do the necessary transfers once you have all your money. Hold that back in future. Otherwise, this is the type of situation that may repeat itself.
Not a pleasant one either.
No, definitely not.
Right. Okay, well, that's the end of the emails. We're going to start taking some calls now. So if you have any questions, 0892 10 2010, 0892 10 2010. And just to let you know, you tune to SAFM, South Africa's news and information leader. I'm Karen Key, and this is the Law Report. My guest tonight is attorney Nicoline Skuman-Low, and she's a director of Skuman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town. We're doing a law clinic, so no fixed topic this evening. As I said, if you have any questions, 0892 10 2010. Linda in Durban, good evening.
Evening, sir.
Hello, Linda. How can you emailed us, but we weren't quite sure where your case was at the moment, so we thought we'd like to talk with you. What exactly is happening at the moment?
Oh, yeah, the case is in Durban. And you see, my wife, as I wrote down, that she just parked the truck and remove all the goods. And the next day, after removing all the goods, he called the police to take me that I'm insulting her. Then the house was still vacant. And they come and took the goods that she left. She wasn't took on the same day, and said the following day what it called the police to lock me up, and she continued taking the goods.
And then after that, she made a claim against you for supporting your children. And then you said they're 18 and 21.
Yes. I received the letter from family court. Family court disagreed because the children were above, and to continue with the case. And the case now, they are deducting the money of 3,000 rand from my salary for her now.
So she's getting spousal support. For the children or for her?
No, for the children.
Are
But
they-
the children were above 18. The one was 18 and the other one was 21.
Are they working?
Is about to finish, but the problem lies on this because I never chased the children. She convinced the children to went with her. Everybody, and yes, it now is going to 5 years now. I'm alone here, and she bought a place to build the house in Kwamakota after she resigned, and she claimed everything of my belongings.
Are you actually divorced now, Linda, or are you still married?
I'm still married because the case is still continued.
Okay, because you said here you didn't receive a cent from her resignation, her pension, but she doesn't, I mean, basically at this point, if you're still married, I mean, she doesn't have to give him anything at this point because it's all joint.
No, it needs to be finalized in
Joint,
court.
yeah. Are you married
Yeah.
in community or property?
Yes, sir. And we married in commercial property, and once in 3 months, she was going overseas for visiting on her own. Not with me. After 15 years, she submitted resignation with KG Hospital, which is King George. And I never received even a cent. Then after that, she said to me, she will show me how full am I.
But the problem is, unfortunately, Linda, I'm sure Nicolene will tell you that this has to be resolved in court in a divorce case.
Yes, and what courts often do is, particularly when children remain financially dependent on the parent, even though they have reached the age of 18, there could be a maintenance order, particularly pending resolving the marital situation. So until the court case has been finalized and divorce has happened, often it does happen for what we call an interim maintenance order, just to deal with the matter until it's finally resolved. So my advice to you would be to, on a urgent basis, to get yourself some legal representation and to try and resolve this matter. I mean, 2013 to now.
Because he said this has been
It's
going on
deleted
for 5
from
years,
the family
basically.
court. Yeah, that's a very long time. It's really
Very
time
long.
to
And
escalate it.
The family court told her, before we take this, did you visit the farms or everything to solve your problem, or you just decide to remove the goods from the house? And she ignored it and she continued with the divorce.
But you need to go and get this divorce sorted out
Yeah,
because it's taking
otherwise-
too long.
No, definitely. This is definitely something you need to resolve sooner rather than later, and that's also the sooner one will be able to move on and not be stuck in this situation any longer.
Yeah, but you see, because to my children, I tell you, I don't just say, whatever you need, I'll be behind you. I'll do everything you want to me. But they want to do it in court. Where my wife convinced them, and you see, all of them, they just evacuate from me.
You need to just go and sort this out between you and your wife. You need to go and get this divorce sorted out.
Definitely.
Okay.
So that's your first step now.
That's your first step, to get yourself an attorney that can also help you in be in your corner, so to speak, when it comes to this divorce. It's quite clearly been very traumatizing. Not handled in the best way, to put it mildly. So I think you need to get yourself some representation so that someone can guide you through this maze, this emotional maze, and the longer this is unresolved, the longer you'll be paying maintenance and all sorts of amounts that will just keep heaping up and piling up, together with these goods that we presumably illegally removed and pensions that have probably been spent and not shared and all these things. The longer this goes on, the worse this is going to get.
Okay.
So you need to get this sorted out as soon as possible, Linda.
I'll do that, because that is going co-country with a company, you see problem. But anyway, I'll try to sort this as soon
Please,
as possible.
good luck to you, huh?
Thank you, sir.
Thank you, Linda. Good night to you. Right, off to Cape Town now. Nina, good evening.
Good evening.
Hello, how can we help you, Nina?
Okay, well, I've got a question relating to loans and regarding sort of the legal department and interest and fees that are added on loan. So this particular loan went through debt review. It was then removed from the debt review because I went off debt review. Then what happened right after that? This particular bank went and added all interest and fees that weren't being accumulated during the period of the debt review onto this particular loan post the debt review. Now, what's obviously occurred is that it's become completely unmanageable. I'm unable to get hold of any staff because this particular bank has been shut down in most of the areas that I can get to. And when I do speak on the phone to the legal department, etc., no one is able to provide me with a detailed billing of all of the amounts with regards to the loan. They also have not been sending me statements for over 2 years. And so my question really, the first part of the question relates to what does the National Credit Act say about a certain, you get a certain amount for a loan and there's a certain interest attached to it. But what happens when that capital amount and interest has already been paid off, and all that's left to be paid off is actually an accumulation of their own costs that have been capped on it?
Well, there's been quite a lot of movement in terms of the theory in regards to National Credit Act and particularly the interests and fees that run concurrently with capital. I have previously mentioned on the program the Antenuptial rule, which is Antenuptial rule. It's something created in terms of the National Credit Act, and in essence, it says that once your admin costs and your legal fees and interest hits the same level as your capital amount, it stops running. So let's say you owe 100 Rand. The minute the interest and the costs accumulate also to 100 Rand, that you owe a total of 200 Rand, it stops running. So there has been a bit of development in this space. So I stand to be corrected how far or how broad this extends, but I can most definitely take your details and send you a bit of information about this in the morning, off of the show, of course.
Yes.
So essentially you would be able to argue that, and foremost, the purpose of debt review is to consolidate all your debt. In other words, that you tally everything that you owe currently, and your debt counselor works out a payment plan so that you could then service all the debts and move on with your life, in essence, without facing a liquidation or something much more invasive than that. So it doesn't sound accurate that they would be, you are done with your debt review and now all of a sudden you have an additional amount that you have to service. So it could be a case of poor record keeping. Which,
well, they won't give her anything. She's asked them and they won't even send her a statement.
Sure, it could be a case of poor record keeping, that they don't know how it occurred because there is no record, or it's just, an opportunistic situation that they are trying to exploit. So it's important that I think we investigate the parameters of the new developments. I'm quite willing to get some information together in the next couple of days and to send it on.
Nina, I'm going to put you back to my producer now. If you can just give him your email address.
Okay.
And then what we'll do is I'll get that information from Nicolene and we'll forward it on to you.
Super, thank you.
Thanks and good luck to you. Thanks for the call.
Yes.
Hold the
Bye.
line. Thanks. Bye-bye now. Right, off to Johannesburg. Linda, good evening. Linda? Hello, Linda in Johannesburg. Are you with us? No, Linda seems to have disappeared. Right, well, we'll just wait a moment because now they're busy. They're taking Nina's details down there. But let's just go back to my favorite topic, which it has been, I'm like a stuck record for the last month, National Wills Week. Let's just remind people again, they've got 5 days, well, 4 left now, Tuesday to Friday.
Yeah. participating firms all around the country. Pro-Bono initiative that we've always proudly taken part in since the firm's inception. We are celebrating our 8th birthday this month. And
congratulations.
Again, thank you. And again, taking part in the initiative. It's really, I think personally, something that is so valuable for our communities. For our elderly that maybe they've never been able to think of the legacy that they would leave behind in terms of having that little bit of extra funds to really pay towards having a professionally drafted will done. So it's so very important to make sure that we give this opportunity to them, and that we don't allow it to slip through the fingers, so to speak.
Right, let's see if Linda in Johannesburg is back with us. Linda, good evening.
Good evening, how are you?
Fine, thanks, and you?
I'm all right. I just have a question quickly.
Okay.
In 2004, we had appointed an attorney to administer an estate late account for my mother's passing on. What he then did was he rounded up all the estate. He opened an estate late account and deposited all the funds to that account. Now later in the year, I was out of the country. When I came back, I found out that he had actually used the funds that were in the account to an amount of about 250,000 rand. Now he gave all sort of explanations as to why he had used the money, and he's going to try and get it back. But to date, he's been every now and then putting 500 rands into the account and giving an explanation and all of that. Now it's almost 10 years later. I just want to know if there's anything that one can do to actually approach this matter and get him, because he's no longer practicing as an attorney, but he's a legal advisor for a bank. If this case could actually expire after a particular period of time, or can one still pursue the matter?
Now, can I just ask you a question? Now, when he was practicing as an attorney, he would have had something called a fidelity fund, surely.
Yes.
But now that he's no longer practicing, would that still cover him, even though he's no longer practicing, but he was at the time of this?
As far as I know, it's about when the incident occurred, where you were finding yourself. Often these guys that do go down the road and do things like that, statistically, we get a pamphlet once a month reporting on these trends in the industry, and more often than not, they leave the profession and they join a big company, albeit a bank or insurance company or whatever, as a in-house advisor, thereby thinking that if you are no longer with a Fidelity Fund certificate, no longer practicing attorney, then you've proverbially dodged the bullet. Criminal cases, and that's what this is, theft of trust funds, misappropriation of trust funds, including funds that were under your control, such as an estate late. That's a very serious matter, and it's a criminal matter. So it does take a long time for it to be investigated by the police, and the police do get involved.
But Linda's been waiting 10 years already. I mean, it's been going on forever.
So if this is reported to the Fidelity Fund at this point, which is essentially like an insurance provision for attorneys, then they will involve the police, and it will be investigated properly, and it does take a long time.
But it's worth doing it, though.
But I think it's worth doing it. I know you have... they may reject it because of the time. They may actually...
but it's worth taking a shot.
At least trying, or at least pursuing criminal charges directly, if not through the Fidelity Fund. If this person is employed, you can always also get yourself an attorney and issue process against them. And then, they do earn a salary. Then they can pay the estate back via garnishee order. So... yes, there is a criminal element to it. Yes, you could go to the Fidelity Fund, but they are quite strict with their timelines. If you've known for longer than, 90 days, you haven't reported it to them, knowing that there's been theft, then they do tend to reject the claims. So it's if you're out of time, it's either going to the police, and then you won't necessarily get your money, but you'll get a conviction, and you'll make the world a bit of a better place.
How would you go about actually getting this garnishee order then? Go to an attorney? Go to
an attorney, issue a summons, and set out the grounds that it was for misappropriation. Alternatively, theft of trust funds. You can't claim against the Fidelity Fund because of the time period. Again, we may then face issues of prescription because it's been so long. So this is really a problematic situation.
Linda, if you want to go, if you want me to put you back to my producer, we can at least give you the contact details for the Fidelity Fund, and your first step is there.
And
yes, if you can assist me with that, if you can put me back through, because what happens, like I said, almost even a month ago, he had sent just deposited randomly maybe 500 into the account. So what I want to know is it always the case that when somebody says I'm willing to pay any amount that is possible? I mean, but it's ridiculous. If you're going to pay something like 200 rands for an amount of 200,000, how many years is one to wait up until all the money is paid in? So I just want to know if can you say that no, I can only afford to pay, for an example, 50 rands on the amount or whatnot.
But basically, prescription wouldn't be running because it wouldn't have run out. It wouldn't be prescribed because he a month ago was still doing this. So I mean, he's still within the limits of prescription. Is 3 years. So
prescription runs when the amount became due. So,
but if he's still sort of in inverted commas servicing the debt, surely then it's not prescribed. It could
be a good argument. But I don't want to say the prescription will not be an issue at all, and then it gets raised and some other details that we are not aware of are forthcoming, and then prescription is a successful defense in this case. So I would say try the Fidelity Fund first, but simultaneously get some legal advice from an attorney that you could share all the information with. And make sure that it's someone you can trust with a good reputation. Call the law society, find out if they're in good standing. Do a bit of homework before you appoint the next one.
Linda, hold the line. I'm going to put you back to my producer, and you can just leave your email address with him, and then we'll be able to forward you that information on the Fidelity Fund.
Okay, thank you.
Thanks. Just hold the line. I think they're actually busy they're taking the call back. Right. Let's see. Anil in Durban. Good evening.
Good evening, Karen K.
Hello, how are you?
I'm okay. I got an appeal for you, not a question. Okay.
Yes.
The thing is, in the law report, I am listening every week, and you either come with the labor laws or with property laws.
Yes.
Or a mix of any of the topics that falls under these two. But normally you have an exclusive law report on home affairs, the immigration roles and on civic services.
I haven't done that for a while because it's very difficult to get a spokesperson from there to come and be on the show, unfortunately.
No, not for the attorney, some Cape Town. So I asked some question about home affairs. I could resolve my issue. So I told my friends and colleagues, you can listen to this one to SAFM. You will get a lot of advice on home affairs issues for visa or all kind of issues. So I would like to know at least Karen K has to arrange at least once in a month or
that's me. Okay. Anil, I'm making a note now. I'm going to do a thing on visas and that sort of thing, but home affairs is always a bit of a difficult one. But I've made a note, and hopefully next month we'll do something on that.
Okay.
I will certainly try and do that for you. Thank you, Anil. Thank you for that.
Thank you.
I always enjoy hearing from the listeners with some ideas for the shows. That'll be great.
Yes, because it is not only for because that South Africa has got around 8 to 9 million immigrants.
Yes.
So they are also in desperate need of advice. So I told my friends, that you can listen to SAFM about this. So they are listening. They are only showing property laws and all that kind
I haven't
things,
done one on that for quite a long time, and I will certainly do another one. So thank you for the reminder. Thank you, Anil.
Thank you. Bye.
Thank you so much. Good night to you. You're listening to SAFM, South Africa's news and information leader. I'm Karen Key, and this is the Law Report. My guest tonight is attorney Nicoline Skuman-Low, and she's a director of Skuman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town. We're doing a law clinic this evening, so there's no fixed topic. And if you have any questions, you can call us now on 0892 10 2010, 0892 10 2010. While we're waiting for our next call to come through, my other favorite topic, as which we had a little bit of an experience with in some of the emails, is where you are married, antenuptial contract or community of property, and you always say that antenuptial is far better. It's safer for both of you.
Sure, I think there's a misconception out there that if you have a conversation about a contract, then you think that it's maybe not going to work out. At the firm, we hold the firm belief that it's all about transparency and about trying to take care of one another from the outset and trying to safeguard the other from any of life's uncertainties, really. I mean, if you are married without a contract, then you're automatically married in community of property. And very few people know what that actually means on a day-to-day basis. You hear the horror stories about the husband or the wife that has overspent and everything's gone belly up and the other one goes with them automatically because they are married in community of property. But the problem is that very few know that for pretty much everything you want to do, you need permission.
Well, I was about to ask you because back in the day, it used to be that the wife had to get the husband's permission. But now, from what I can gather, you both have to sign everything.
Yes.
You can't just, I can't go and open up my own bank account, for example.
Exactly.
You have to get your husband to come with. I seriously would not cope with that.
And how do you synchronize schedules in
exactly.
today's busy lifestyle?
Yeah, you can't do anything alone.
It's a real practical issue. And many people don't know this. They don't do this. So, unfortunately, many of those transactions could become legally unenforceable,
yes.
which may be good or bad, but in essence, it's really a problem. And of course, if whoever passes away first, I did briefly mention it now, that you'll leave the other one in a pickle.
But besides that, the estate is frozen.
The
And
estate is frozen, so if you
on?
don't have access to some other funds or something that are exclusively yours, then you're without money. And that's a massive problem. So it's really for more than one reason. It's really not something I think personally is well suited to today's way of living and all the risks and the busyness of life. I just don't think it's very practical.
You need to be able to control your own life to a point.
Exactly.
I mean, you are together as when you're married, but there are certain things that you need to be able to do independently. So that's really what it is.
Of course, and why do you want someone to dictate for you what you share and when you share? It's not about being selfish, but what about thinking, how is the best way of doing this? And when you have an antenup, depending, of course, how you structure it, you can decide, okay, let's share on this way now because you are going through a tough time and I love you and I want to help you. And it doesn't have to tally out to the cent in a budget or whatever the case may be. It can just be done because of choice as opposed to some regulation dictating that you have to do it. So it's all about exercising what we as humans love, the power of free choice.
And our independence.
Yes.
Right. Mary in Caledon, good evening.
Good evening. I have a small flat which I let out for a year. The person has now moved out. The lessee has said that they will paint the lounge and the bedroom. And I just want to know if that's par for the course. They don't have to do the bathroom and they don't have to do the kitchen.
Well, it really depends what the lease agreement says, but in a nutshell, they need to give or return the property in the state that it was given to them. So, by example, if the walls were one color and were free from any marks of nails being pulled out and whatnot, and maybe some other forms of damage, then of course you can enforce that they have to paint.
There are no holes. There's nothing.
But is it one color?
Yeah.
Okay, so if it's reasonably in the same state, then you can't really enforce
Okay.
that. It's all about damage, really, and about it being in the same state.
That's fair. And the other question I wanted to ask is, they approached me after about 6 months, and they said that they had a relative who was out of work. He's disabled, didn't have an income, and would I mind if he moved in? And I felt sorry for them, and I said, okay, let him move in. And then a girlfriend of mine went to the flat to do a floor plan, and she came back and she said, the bedroom smells of urine, and it's bad. It really is bad. So I phoned them, and they said they couldn't smell anything. And I thought, oh, God, okay. So I went down about 10 days ago, and as I walked into the flat, it hit me. I could smell it. So they got somebody in, and the guy used a vacuum cleaner with soapy water, and went back the next day and could still smell it. And we had windows open, but we can't sleep with the windows open because of the wind.
Sure.
So then he said to me, well, it's an old carpet. And I said, that's not the point. You didn't get it with the urine smell. And so now finally, after getting a little unpleasant with me, said to me, right, what they'll do is they'll get a professional in and lift the carpet and put new underfelt just where the urine is.
Well, didn't you take a security deposit from them when they moved in?
Yes.
Utilize that and get it done properly. I mean, this is not my technical expertise, obviously, but from practical personal experience, it would just be better to replace the carpet in its totality.
How I felt.
And that's quite
but he should be
reasonable.
replacing the carpet. My feeling is...
Well, if you've got the security deposit, Mary, you can use that money to put the new carpet in.
I would just go and do that, have control over it, and get it done properly.
Yeah, I get quite unpleasant about it.
Well, it's just unfortunate for them. They ruined the carpet, and now you have to replace it. So. Okay.
Yeah, that's what I thought. Replace the carpet.
Yeah, well,
and stop with the going on and on and on about
that's
it.
What I would do.
It is strong, and they say they can't smell it.
Well, because they probably got used to it now. You live in something long enough, you're not going to notice it. So.
Yeah, but this is the relatives who go and visit.
Oh, well.
And they say that they can't smell it.
Well,
it is so strong. And, of course, when the sun comes in during the day...
It's worse.
It's worse.
Well, I would take that security deposit and just replace the carpet, to be honest. Okay. Thanks, Mary. Thanks. Good luck. Good night to you. Bye-bye.
Good night.
I think we might have time to squeeze in one more call if it's quite brief. Omar in Cape Town, good evening.
Good evening. I just wanted to comment or ask, the lady that called in, Linda, the misappropriation of funds.
Oh, yes, the attorney, yes.
Yes. If he was paying small amounts, up to recently, wouldn't the prescription be interrupted?
That's what I said, yeah.
Yes.
That's what I thought.
But my comment was, even though that could be the case, we haven't had a proper consultation and looked at all the documents and look at all the factors. So I don't want to make any definitive or absolute statements that could be misleading. So I acknowledge that can be the case, but we don't have all the information to make an informed judgment on it. It's needed to go to an attorney to really unpack all of the information and to prepare the case appropriately.
And shouldn't she go? Her first port of call would be the Law Society.
The Law Society, but they cannot impose or compel someone to pay. That's again where it goes back to the Fidelity Fund. The Law Society is similar to an ombud structure. So they, if there's any allegations of unprofessional conduct or anything like that, they call you for a disciplinary hearing and they give you a fine, or if it's been bad enough, they actually remove you from the role, but they can't actually make you pay the money back. They can discipline you, but not make you pay the money back. That's either a court of law or the Fidelity Fund that can compel, and it's usually all through either police, criminal, and court structures. It's quite a formal and invasive process.
Okay, thank you very much.
Thank you, Omar. Thanks for helping us to clarify that. Thank you.
Have a good evening.
Thanks.
Bye-bye.
Thank you. Good night to you. So, but it could end up costing quite a lot more money if you're going to then take this to court, surely.
It could, and
Can you do it and claim costs from the other person as well?
Of course you can. But in this, I think this listener is in a better position than many others where this perpetrator hasn't, stopped practicing and is maybe not in the country anymore or something like that.
And is earning an income.
But at least this person is employed. They're presumably employed for a relatively good salary if it's with one of the banks. So at least there's something to attach to get the money to be repaid. I mean, over the period of 2 years, 200,000 Rand, 10,000 Rand a month, that would have been long settled if it was maybe handled with a little more integrity from the outset.
And this is another one of those things, we talk about it a lot when Michael Bagram is here with the labour law. Don't leave things.
Don't.
And Michael always says, if something goes wrong, don't wait until the end of the month. Do it now. Sort it out now. Make inquiries now and get the thing started now. As you said, 10 years down the line, as you said, possibly 90 days with the Fidelity
problem
Fund.
is, even if it's not an issue of only prescription, the court will at some point ask the question, why did you wait for 10 years? And we need to, the listener has to unpack that with their legal representative so that you can construct your case correctly from the outset. It's not just a case of prescription that concerns me. I think we need to give it its airtime, even if it's with another attorney.
As we said here again,
get all the
don't
facts.
leave things. Do them straight away.
Yes.
Well, my thanks once again this evening to Nicoline Skuman-Low. She's a director of Skuman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town, and she's been my guest on tonight's edition of the Law Report program. Nicoline, once again, thank you very much for joining me.
Thank you for having me, as always.
And Nicoline will be back with us again for another law clinic on Monday, the 12th of October. And just apologies to all those listeners who couldn't get through. We had a lot of them waiting to get on, but we kind of ran out of time, as we usually do on the show. So thank you, though. I do apologise. And we'll be back again with you next Monday evening. We're hoping to do something on medical malpractice, but that's not yet confirmed. So let's hope that will happen with attorney Ian Dutton, and hopefully we'll know later this week. It'll be confirmed. But I'll be back with you again tomorrow evening just after 9 with Health Matters, so join me then. And Stephen Kirk is up now with some nighttime music. Hello, Stephen.